Okay, recording started.
Great. Call to order the special hearing of the Beverages Licensing Authority for Wednesday, April 3rd, 2024 at 2 p.m.
Thank you so much. We will start with our rules of decorum. And give me just a second. I just closed off it. Sorry, it's loading. Okay, here we go. Okay. The city has engaged with community members to co-create a vision for productive, meaningful, and inclusive civic conversations. This vision supports physical and emotional safety for community members, staff, and board and commission members, as well as democracy for people of all ages, identities, lived experiences, and political perspectives. More about this vision and the project's community engagement process can be found on our website. The following are examples of rules of decorum found in the Boulder Revised Code and other guidelines that support this vision. These will be upheld during this meeting. All remarks and testimony should be limited to matters related to city business. No participant shall make threats or use other forms of intimidation against any person. Obscenity, racial epithets, and other speech and behavior that disrupts or otherwise impedes the ability to conduct the meeting are prohibited. Participants are required to sign up to speak using the name they are commonly known by, and individuals must display their whole name before being allowed to speak online. Currently, only audio testimony is permitted online. There is a Q&A function for this meeting that is mostly for technical difficulties. Please don't put any sort of public comment in that. And next we will move on to roll call. If you'll just speak your presence aloud. Member Mike Absalom.
Member Absalom present.
Member Michael Carr.
Member Carr present.
Chair Matt Califano.
Chair Califano present.
Member Leah Roberts.
Member Roberts present.
Perfect, thank you. And we have one item on this agenda today, and that is agenda item number 1, show cause hearing concerning alleged violations and whether the hotel restaurant type liquor license held by 13th Street The Hill LLC, DBA Taco Junkie, 1149 13th Street, Boulder, Colorado 80302 should be suspended or revoked. If you are here to speak on this matter, please go ahead and raise your hand, and I will let you into the meeting. And while everyone is getting let into the meeting, I'll just let the board know that this licensee is not approved by sales tax or occupation tax at this time. And I think great. It looks like everyone is who had their hand raised is in the meeting. And I believe we have some attorneys here. So if you are an attorney that's going to be appearing for this matter, can you please record your appearance for me?
Good afternoon, board. Christopher Reynolds, Deputy City Attorney for the City of Boulder, license number 42282.
Good afternoon. My name is Christopher Carr, registration 32239. I'm appearing on behalf of one of the owners of the licensee, Angela Caravello.
This is Jason Savala, 27843, and I'm representing Mr. Caravello, one of the owners.
Thank you. And I will get anyone who's going to be giving testimony sworn in first, and then I'll hand it over to the chair. If you're going to be giving testimony or think you might be giving testimony and your attorneys can confirm or deny, go ahead and let me know and I'll get sworn
I apologize for interrupting.
Nope.
Perhaps before we do swearing in of any potential witnesses, the matter of a potential stipulation should be is before the board. And so it would be, I believe, most appropriate for the matter of the stipulation to be discussed, and then we would submit it. And I believe Ms. Teague has that and can submit it to the board members for review, and then potential acceptance of the stipulation. And that will determine whether or not anyone needs to be sworn in, who needs to be sworn in, if anyone at all.
Certainly, we can go ahead and do that. Caitlin actually has that stip ready to distribute out to the BLA members.
If I
Chair,
can,
one
sorry,
moment, please.
go ahead.
Chair Califano, once that's sent out, you would be able to take a brief recess to review. Apologies, Mr. Savella.
I'm sorry, and I interrupted you. I apologize. I guess what I'd like to say is that Taco Junkie and the other business that is associated would be willing to voluntarily surrender their license if that is an option. If that's not an option, then the stipulation is something that we're willing to go with, and there's a signature and further. But we wanted to make sure that the board knew that we're essentially trying to voluntarily surrender, either directly in that fashion or through the stipulation. Thank you.
Caitlin, let me know when you've gone ahead and emailed that out.
That has been sent.
Just waiting for it.
Okay, I see we have a hand raised from City Attorney Ramirez.
Yes, thank you. So before the stipulation is considered, I would like the board to note that it has only been executed by one attorney. And so before you even consider it, I would like to clarify, because it does appear that there are two counsel, that there are two members of the business, and ensure that that is representative of both parties.
It is. We weren't given a copy to sign, but Mr. Savala did share the stipulation with me. I did agree to it. Signing it on behalf of the company, since I guess in theory the company is the one that is signing it, not either individual owner. But we are in agreement as well that we would prefer to voluntarily surrender the license if possible.
All right, thank
All right, so it's been received. Do we want to take a 5-minute recess? What do the board members think about that? All right, so let's convene at, we'll say 6 minutes to 15 p.m. Just waiting on one more member. All right. So hearing is back adjourned or open. Is there any motion from the board to accept the stipulation?
Member Carr will make a motion to accept the stipulation agreement. Member Absalom would second.
All in favor say aye. Member Califano, aye.
Member Absalom, aye. Member Carr, aye.
Member Roberts, aye.
Okay, so Caitlin, are we able to get some people sworn in if necessary?
I'm going to go ahead and turn to the attorneys on this so they can kind of give us a guide on what next step would be. And just for the record, that motion to accept the stipulation was did pass. So I don't know that we need to take any testimony or anything like that, but I'll let Roberto chime in.
Thank you. You certainly, it's going to depend as to whether you want to take testimony, and that will depend on whether you accept or how you want to proceed. Uh, Counsel for the licensee indicated that the business would surrender the license. So for point of clarification for the BLA, and you can decide how you wish to proceed. Nothing prevents the licensee from surrendering the license. However, the BLA can still move forward to consider revocation. According to your licensing staff, there is a difference between a license being revoked and a license being surrendered. As I understand it, and Kristen T could correct me, a surrendered license has no future consequences. A revocation, however, would be a factor in granting a future license in the state of Colorado.
Kristen, anything you wanted to add?
No, that is correct. A surrender, anyone can surrender a liquor license at any time for any reason, as long as they're not attempting to avoid prosecution. Since there was a STIP already submitted for this, I do not believe that, they did STIP to revoke. A revocation, they would have to report in the future should they decide to try and apply for another liquor license. It's not a reason for a denial of a license per se. It's just a factor that is taken into consideration for any future liquor licenses submitted within the state of Colorado.
Thank you. So what does the board think? The closest case I can think to this was we still asked the applicants about the charges. We determined, if or what they were and their punishment, and then instead, not their punishment, their suspension. And what we did was, rather than give a suspension, is we accepted their surrendering of the license as their violation.
So that is correct. We have done that on occasion. And then there's also been straight revocation by the board in the past.
So reading through the stipulation agreement, what I noticed is that it already states that the license has been agreed to be revoked by the city of Boulder. So isn't that already kind of answered?
That's my understanding. Is that it's already.
Nothing would prevent you from not accepting that portion of the stipulation. So a lot of times when you see a stipulation as to the facts, and then you decide the punishment here, or not the punishment, but the penalty. Here, that has been agreed upon, and you can certainly move, if you wish, not to accept that portion of it. If the board votes and a majority agrees to accept the surrender of the license versus the revocation, completely up to the board. But that would require another motion.
How's the rest of the board feel about any decision on this?
I mean, based on the preponderance of facts that we're looking at, I'm saying I would make a motion for revocation of the license.
I second that motion for revocation of the license.
That was member Absalom making a motion of revocation of the license.
Is there any discussion on this?
It's pretty clear to me. That's why I made the motion. So I don't know if anyone else wants to share.
I agree. It's the stipulation. There's a ton of evidence. I think there was some reckless behavior. I think this would prevent future reckless behavior. And it is what was agreed upon.
I would agree with that as well. Just in the fact that, they were notified, they had 2 weeks, there was no mitigating factors put together whatsoever. Yeah. Mr. Reynolds, did you have something you wanted to add?
Thank you very much. So the city was prepared for a full contested hearing today, and I do want to just thank Attorney Carr and Attorney Savala for their communication. This is a pretty quick turnaround. It would be the city's position that we would like to present just a little bit of evidence in aggravation on this case, a very small amount. We have one exhibit that has been submitted. It's been shared with the attorneys. It's a body-worn camera from Boulder police officers responding to Taco Junkie. And I'd like that opportunity, but it's up to the board whether or not to grant that. I don't believe it would take very much time. It would be much less evidence presentation than I was prepared to do today. But that is what I would like to ask the board. But I do see that Mr. Savala has his hand up as well.
Mr. Savella?
Thank you. Well, I do notice that the notice of the hearing and et cetera was sent out. I believe it was Friday before last. We did not receive an actual copy of it until Monday. We knew something was going on. That's not the issue. But we weren't able to review this, and we didn't prepare mitigation because we were looking at the stipulation and surrendering the license anyway. So we're not ready to present mitigation. And basically, if there's going to be aggravation presented against us, then we would like the opportunity to present mitigation. So we would ask for a continuance so that we could do such. Mr. Reynolds and I worked on this for the last couple of days. We're trying to, one, avoid a lengthy hearing that is not necessary, and two, to resolve this case with our clients learning what we're supposed to learn, essentially privately. I was hoping to save the board some time. So we would like to go forward with this today if we could, but if we're going to have some kind of an aggravated hearing, then we're going to want to present mitigation. Thank you.
Well, thank you for that explanation, Mr. Savella. However, given the severity of these charges, we were hoping for something, this was taken a little more seriously, and that we would have some mitigating factors from your clients. However, that did not happen. How does the board feel about Mr. Reynolds presenting some of this evidence?
This is Member Absalom. I don't have any problem with it. I'm just, if there is a motion already from the board to go and revoke the license, I would ask Mr. Reynolds the reasoning behind presenting this evidence. Just for the record, is that the purpose?
It's essentially, yes, as it being a public hearing, and this, I think the community has an interest in a full airing of the facts. And while it is not my intention to present the same case I would in a contested hearing, a picture is worth 1,000 words. And I do have a 2.5 minute video clip that Officer Spinney from the Boulder Police Department is here and can speak on a little bit. And so I don't believe it would take up much time to present this. But as I said, I think sometimes, when you read something on an affidavit or in a stipulation of facts, it kind of, people take it one way. But then if you actually see something with your eyes and kind of experience perhaps what it looked like in the moment, it further demonstrates, to the community, the potential, what was actually happening here in a different way. And so that would be the purpose of it.
Member Califano would be okay with that.
I think for documentation and court record purposes, we should see it as a community member. If I wasn't on the board, I would be interested, and I think it's only fair that there is a record.
Well, just to be clear, as a presented exhibit isn't always going to be, it's going to be presented on the agenda, correct? For public record, if licensing, is that the truth? Yeah.
It
Yeah.
is currently, oh, sorry, Caitlin, go ahead.
This was sent to you in an email earlier, and it is currently available to the public right now.
No, I've reviewed the footage. I'm just saying, just for referencing sake, that it's there. But I will agree with Member Roberts as a member of the community. I will second Member Califano's motion to go ahead and review the exhibit.
Don't think we need a motion for that really, but Member
I-
Carr, Roberts, you agree?
Yeah, I agree. We should.
All right, Mr. Reynolds, if you may.
Mr. Califano, Attorney Carr has had his hand raised for
Oh,
quite some time.
apologies. Mr. Carr?
No problem. I just didn't want to interrupt. I would object to the video, obviously with the stipulation as well as with the current motion that the authority has granted, which is to revoke, or at least is pending to revoke the license. There's no reason and no logical reason for any aggravation to be provided, because you can't get a more aggravated result to this case than revocation of the license. We can't revoke it twice. We can't do anything like that. So I think it's unnecessary. I don't think it's needed, especially when the facts that the authority can consider for penalty purposes has been stipulated to in the stipulation, and we haven't stipulated to facts outside of that. So I would object to the video being played. I think everybody's seen it. I think everybody knows what's in it anyway, but I don't think it's necessary, and would object to it happening here today.
Mr. Savella?
We would join that objection. And when I read through the packet that was sent to us that we got on Monday, it indicated that a stipulation can be presented by the prosecutor and the parties. And the board can either accept it or reject it. If it rejects it, then a hearing can happen. So it seems to me that by the rule, you have to accept it and accept it as is or reject it. And then we have the full hearing, which I don't think anybody wants. Now, I'm not, I'm just trying to say that's what I thought the rule said.
Roberto, can you clarify what you meant when you had said that we can accept the stipulation without that one point?
Yes, and that was based on the request from council to accept the surrendering of the license. Because normally in these types of hearings, we only receive stipulations as to the facts, not necessarily as to the penalty. With regards to the matters in aggravation, I tend to agree with Mr. Carr in that you can't revoke a license twice. If it's already been provided to the members of the BLA, I'm not sure that it would be for purposes of aggravation, however, as opposed to a mere presentation. But again, I don't know what the purpose of that would be for the BLA. Certainly you can decide that.
Hearing Mr. Carr and Mr. Savella's objection, and after speaking with Mr. Ramirez, I do kind of agree now that we've seen this evidence. It is public. We have been presented it already. So I'm not sure seeing it again at this point would really be beneficial. How do the other board members feel?
I tend to agree with that. I think those were valid statements.
Yeah, I think it's in the public record. So anyone from the public can view that video if they're interested. And Mr. Carr makes a good point that we can't revoke the license twice. So I'm not sure I see the purpose.
Yeah, I'll just reiterate what I said. Public record is there. I agree.
I would sustain the objection from Mr. Carr and Mr. Savella. At this point, we would go back to our original motion of revoking the license. Any more discussion, or do we want to vote on it? Not seeing any. Mike?
No, I was willing to make the motion if we need to do that again.
I think we have a motion in a second, a first and a second, so we're good for there.
Thanks.
At this point, Member Califano would vote yes for the revocation in the instance that what's to say this licensee not going somewhere else and doing the same behavior. It was pretty substantial and severe for what they were doing. And I could just see them moving to a new location and doing the same thing. So. Member Califano votes aye. All in favor, vote aye.
Member Absalom, aye.
Member Carr, aye.
Member Roberts, aye.
All right, so we have passed the revocation of this liquor license.
Thank you. I don't know that there's any other action or matters that need to be taken, but again, if any of the attorneys or someone else wants to chime in on that, go ahead.
Nothing further from us. Thank you very much for your time today.
Staff would make the note about the outstanding tax obligations, and then the process to wrap up matters at the licensed location as it pertains to alcohol stock on premises.
That would be Officer Rex, correct?
And staff here. Mhm.
Yeah, are there any questions either from staff or from Officer Rec to the licensees as to, or the licensee as to what is currently in stock?
Apologies, Deputy Attorney Ramirez, would you state that again for me?
Sure. As I understand the process from a licensing perspective, the open alcohol must be destroyed in some manner. There must be some sort of stock being taken, and there has to be some sort of disposition. And I didn't know if either licensing or Officer Rec had a question for the licensee as to what is remaining or how that process will occur.
Certainly, I can speak to that, and then Officer Rec. With prior matters with other licensees on this, the process has been for the alcohol that is open and not to be returned has to be witnessed as being destroyed immediately. There has to be an inventory of alcohol that could be returned to the suppliers for credit to the business. And then we receive confirmation of that, those returns within 5 days. I have done those in the past. I would ask that some of these I had to do during the pandemic, so it was done virtually, but most of them had been done in person with both licensed staff and the alcohol enforcement officer, because alcohol is no longer allowed on the premises. It can't be taken home. It can't be given away. It can't be, you know, consumed as a last hurrah, anything like that. So I would recommend that, you know, we make arrangements to do that as quickly as possible. And then, of course, there are the tax obligations that would need to be taken care of, but that's administrative through the city. Officer Rec, do you have anything?
I just wonder, do we need to arrange a time? I mean, I'd like, as they said, as it was stated, sooner than later. So how do we go about arranging that appointment to meet up there to witness that?
Attorneys Savala and Carr, I don't know what Officer Rec's availability is. I am available this afternoon.
My client's not involved in the day-to-day operations of the facility, so I'll let Mr. Savala speak to that with his client. I think they're the ones that you're going to want to coordinate with as to timing.
And if we could do something tomorrow, but certainly if I can get your phone number, then we'll work to arrange that. Or we can also, I have your email, I believe, so we can work that way. But I think sometime tomorrow.
Officer Rec, would that be acceptable to you?
I can make myself available.
Okay. We will coordinate via email. Attorney Carr, would you like to be included in that email thread?
Sure, if it's an email, that's fine. Again, I don't plan on being present. I don't think it's necessary for
Right.
all of us to be, but it'd be helpful just so that my client knows what's happening when. That would be helpful.
Okay. Yeah, we can go ahead and coordinate that for as soon as possible tomorrow, with the assurance that no alcohol leaves the premises today or is consumed. Additionally, we will send information regarding tax obligations and the deadline for that. Is that okay, Attorney Savella?
Yes, that is okay.
Okay. There will be additional documentation coming for the revocation. In addition, in the next day or two, it's just the formal from the city.
Great. Caitlin, is there anything else we need to do at this point then?
I don't believe so.
All right. Member Califano would make a motion to adjourn.
Member Absalom would second.
All in favor, say aye. Member Califano, aye.
Member Absalom, aye.
Member Carr, aye.
Member Roberts, aye.
And we are adjourned at 2:38 p.m.
Thank you for your time.
Thank you.
Thank you.
all.